Good morning. Just flipping through my bookshelf, and I pulled this appellate brief out. Took a quick look at it. Looks like it's from southern Peru. Thought it'd be fun to talk about it today. What do you think?
Well, let's talk about it. It was a big case
It was a big case.
for us, and we put a lot of work into it, but let's try to explain it to everyone.
All right, sounds good. Well, yeah, this was your baby. Yeah, how did Prickett Jones end up involved in this case?
Literally, a guy called me and said, I'm a shareholder of Southern Peru Copper Corporation. There's a transaction happening, and I really don't like. I think it's unfair. Will you look at it for me? So we dove into it, and we were a little. It's been 10 years, so I can't remember exactly. My memory's not perfect, but we were on the later side. It was closer to the proxy statement. I can't remember if it was the official proxy statement that was out at the time that we were called, or it was preliminary, but it was. My recollection is there wasn't like a ton of time to do something initially, but we spent a lot of time looking at the proxy statement, and I mean, I don't want to say it was a simple transaction, but basically the controlling it was there was a company, publicly traded New York Stock Exchange company called Southern Peru Copper Corporation that was that basically was a copper mining company that had its operations in Peru, but they had a controlling shareholder. There was a shareholder, Grupo Mexico, that was based in Mexico, that owned in excess of 50% of the voting shares of Southern Copper, what I'll call Southern Copper. They changed the name from Southern Peru to Southern Copper, so it's called Southern Copper. And the controlling shareholder decided to sort of consolidate. They were essentially a holding company. They owned other businesses, and one of their other businesses was also a copper mining operation, but it was located in Mexico. And so they decided to propose to essentially what I consider sell their Mexican copper mining operations to the the other company they controlled, Southern Copper, and they wanted to take back shares in exchange. I mean, so really that's all it was they were moving a Mexican copper mining operation into another company that they controlled.
Right.
And there kind of weren't any synergies. They were copper mining operations in different parts of the world, but they wanted to put them together, and they proposed to put them together. And that's how it started.
And in and of itself, there's nothing wrong with a controlling stockholder reorganizing its business interests, right?
Nothing. It's all about basically whether it's a fair deal. And I don't want to jump to the end at the beginning, but they proposed they basically, Grupo Mexico came in, and there were some subsidiaries, but basically it was Grupo Mexico was the controlling entity. They said, hey, our Mexican mining operations are worth about $3.1 billion, we think. So we want $3.1 billion in your stock, measured at the market price, because it was publicly traded New York Stock Exchange stock. And that was the initial offer.
Right.
And at the end, they got $3.7 billion of stock. So if they had just, if the company had just accepted the original offer, it would have been, they would have done far, far better than they did in the end. So it was a very, very, to me, a very strange situation.
And that was something that popped out right from your initial review of the case.
That's what when I looked at it, I'm like, it was actually quite complicated. The way they had appointed a special committee, and it just didn't strike me as, the way they approached it seemed bizarre to me. They, instead of just looking at it like, okay, we're buying a Mexican, or we're buying some copper mining operations, what's it worth? Let's pay them what it's worth. They ended up doing this weird, what they called a relative valuation analysis, which to this day I don't even understand. Instead of just saying, what are we buying, and what's the fair price for it, they ended up sort of trying to justify it, because a lot of people on the on the southern Peru side just seemed like they were really anxious to get something done. We can talk about the details in a second, but
Right, yeah, and trying not to skip all the way to the end.
Yeah.
I guess, so straight from the SEC filings, at least, red flags jumped out at you, right? It's fair to say that once you parse through the convoluted way the SEC proxy was prepared, you could figure out that at least Southern Peru was paying a lot more than Grupo Mexico even initially proposed in the transaction.
That was the weird thing in the end, and you actually couldn't tell it from the proxy statement, because the proxy statement was very sort of confused and hard to follow and hard to figure out what was really happening. But when we really did the work and dug into it, it was clear that, or it seemed to me that they were reaching to try to figure a way to say that it was fair, versus just saying, we're issuing shares of a publicly traded New York Stock Exchange company that have an actual market value that is, you really can't argue with. It is worth what it's worth. And to me, the focus should have been what was Minera Mexico, which was the southern, was the Mexican mining operations that were being sold or moved into Southern Copper. It should have been focused on what they were worth. And actually, in the end, there wasn't any dispute. At trial, nobody argued a really different value for Minera Mexico. It turned into, or the way the case evolved, the defendants sort of, their argument changed over time, but it evolved into, the basic issue was, don't look at the market price of the shares that we're getting back. We're going to do a discounted cash flow valuation. And we think it's, if we do a discounted cash flow valuation of the shares of Southern Copper that we're getting back, they're worth a lot less than the market price.
Right.
And that was the essence of the case. And the essence of our argument was, this is not an appraisal case. You're dealing with essentially cash, shares that could be sold to the public to produce the market price. And the defendants never said that those shares, even though they were issuing 67 million shares, the defendants never said they're not worth the market price, or they couldn't be sold for the market price. They just argued that we should do a discounted cash flow valuation, and maybe some other valuation methodologies for those shares, and get it, and we come up with a lower value.
Right. And I guess, stepping back a little bit and thinking about from the parties in play, the people that were looking at this. And for me, as I look back on it 8-9 years later, it's hard to not look at it also through the way the law has developed since. Particularly, we've got the Corwin Doctrine, we've got MFW in play now here in Delaware. But looking at this transaction, the parties in play, I mean, the special committee, you recall, I mean, the individuals, were they qualified? Could you tell just from the SEC filings whether there was conflicts of interest or any undue influence that at least the controlling stockholder could have placed on the special committee?
It was unusual because the special committee members seemed highly qualified. And the lead special committee member, Harold Handelsman, was an attorney. There were several other large shareholders besides
Right.
Southern Copper.
And just, I guess so we had Ruiz, who was the chair of the special committee, right? And then
I thought it was Handelsman that was the chair of the special committee.
So Handelsman represented, the Pritzker's interest,
Yeah,
which
so-
was a huge.
Yeah, so Harold Handelsman was an extremely successful lawyer, and really had an impeccable reputation. And he was a very senior lawyer for the Pritzker organization. The Pritzkers are a billionaire family from Chicago that have many business interests, and they were sort of famously involved in Smith versus Van Gorkum. They were the buyers in Smith versus Van Gorkum in that case. And Harold Handelsman had a long career and understood the law, and I don't believe intended to really do anything wrong. But he was at the very end of I believe he was the lead, more or less the lead person on the special committee. And he was trying to get the Pritzkers out. The Pritzker organization had a significant investment in Southern Copper. And so his orders were, we want out. Like, we want get as much money for us and get us out. And he was at the end of his career. He was retiring, and he was just trying to get a deal done. And he was we can all read the opinions. That there's a 100+ page opinion from the Delaware Supreme Court that outlines everything. So there's far more in there than I can explain today. But Handelsman, even though none of us really believe he had it didn't seem like he had a motive. He wasn't trying to steal money or cheat anybody or anything. But it was just a weird set of circumstances that he was at the end of his career. His job was to get his company or his investors out. And so he was reaching, like trying to find a way to get the deal done. And when Goldman's, they hired the best investment bankers in the world.
Which was going to be my next question about the advisors. So the committee was built up of very reputable business.
They had Latham and Watkins representing them. They had Goldman Sachs. I mean, they're the best, essentially. And they came in initially, and I think everyone thought, like, okay, what's proposed really isn't fair. And Handelsman actually testified at trial, and we all fell down when he said it. And I remember, I'll never forget it, that, well, it wasn't fair. We didn't think it was fair, but then we had the idea to tell them to do a discounted cash flow valuation and see if the stock, we see if we could say the stock that we were getting was worth less than the market price.
Right.
The real value was less than the market price. And that, and his comments, again, it's all detailed in the opinion, so it's hard to quote it all. But I mean, he said, yeah, once we got them to say that the stock that we were getting was worth less than $3 billion, we all got comfortable with it. And it was just a weird situation, I think, where there was a committee, even though they were all highly qualified, presumably or seemingly independent people, for very strange reasons, they all were just desperate to get a deal done.
And it was, either through that desperation or otherwise, to delve into that, I mean, it really required a tremendous amount of discovery on our part to understand what happened. It seems so. If you thinking back to this, as then Chancellor Strine had phrased it, the rationalizing a deal rather than negotiating one. This idea that relative valuation is almost as if they're treating this as a merger of equals, right? And then the question became, were they comparing apples to apples? And through the discovery, I mean, how was Monera treated in preparing for this relative valuation as compared to, say, Southern Peru?
Listen, to this day, I really don't understand this term relative valuation. They're buying something. They were buying a business. They weren't paying cash, but they were paying publicly traded, they were delivering publicly traded stock, which no one disputed that you could have done an IPO or a public offering of that publicly traded stock, produced cash and paid cash for the business. I mean, this was just a purchase by the controlling shareholder, by a controlled company of some assets they owned. And so it always struck me as, I don't understand why you wouldn't just say, what is it, what are we buying and what's it worth? And it really was not, it was a different mining company from southern Peru. Their operations were not tremendously successful. They were suffering. They had a bunch of employment disputes. There were strikes. Their equipment, we had pictures of their equipment rusting, sitting in a rusted pile on the ground in Mexico, versus southern Peru mining operations, which were run beautifully and working great and producing money. So I'm not,
And that was really...
and this is how it started,
Right.
because when Grupo Mexico made a proposal, their proposal was very simple. We want to sell you a business that we claim is worth, I forget the exact numbers, but $3.1 billion. And we want $3.1 billion of stock measured at the market price.
Right.
And the committee then looked at it, and their advisors said, what we're buying it's not worth $3.1 billion. It's $2 billion or less. Actually, there were some valuations that it was 200 million. But they, instead of actually negotiating like a third party would, they, for whatever reason, and I think it's because a lot of the committee members just were just anxious to have a transaction completed. At least that's what the opinions concluded. They sort of got diverted into a process where they didn't negotiate, really. I mean, there were some minor changes to the transaction that actually made it worse, that actually made the price that Southern Copper paid higher. But they tried to make some adjustments.
Right.
But that's, I think, as the court said, that's not what a third party would have done. A real third party would have said, no, we're willing to buy your business, but here's what we think it's worth, and so here's what we'll pay you. And
Right.
there was never a negotiation really in that way.
And I think that's, as it comes across in the opinion, I think what was shocking to the chancellor was, while the defendants wanted to say, look, you should value Minera Mexico the same way the market values Southern Peru. And on a relative basis, if you do it that way, we're worth, as much as Southern Peru paid for us. But looking back at the scenarios, and this is like how, it was surprising to see I mean, I don't think he believed us for a long time until finally when the opinion comes out. If you recall, he even had in addition to everything we told him about the problem with comparing Southern Peru to Minera Mexico, he actually had laid out his own chart, which showed the deal anticipated that. For every dollar of EBITDA or whatever, Southern Peru was going to generate, Minera Mexico was going to generate $1.36 or something. But in actuality, on his own analysis, showed that what Minera Mexico could produce was a fraction of that.
Right, and there were a lot of complicated valuation issues here. Some of which, at one point, they essentially said. The defendants were saying Southern Copper is publicly traded, so we have multiples. We have actual ways to measure the value of that. Let's just apply those. Their argument was, well, its multiples should just apply to Minera Mexico. And that was a silly argument because even though they were both copper mining companies, they were in tremendously different situations. One was a very successful company, one was not.
Right. Handelsman even said at his deposition.
They admitted it. It was, like I said, we had Google Earth shots of the absolute mess that Minera Mexico's operations were, and they were, they were just a mess.
Right.
And they had a lot of debt.
Right.
Southern Copper had basically no debt. And there were a couple other big issues. Like the one way, in the end, to me, the core way the defense tried to justify this was to say, well, in valuing a mining operations, really the key is what is the copper worth,
Right.
And internally, Southern Copper valued, had a projected long-term value for copper of 90 cents a share.
Right.
And that's what they used for all their valuations and all their plans. And the defendants then came in with an expert and said, no, it should be, I forget the exact number, $1.20 or $1.30.
$1.35.
$1.35. Okay, you remember better than me. And which was sort of silly to me. I mean, you can't, actually both companies were, for their internal purposes, were using 90 cents a share as, the way to value the underlying assets. But what the weird thing to me was, and I didn't really understand it until we got into the case and worked with experts and talked about it, but valuing a sort of resource company, it's not everything that's in the ground. Right. It's not all the copper or oil or whatever it's in the ground. You have to start with whatever you project the long-term reasonable price is, because it's what you can get out of the ground at a profit. Because there's more down deeper, but if you can't get it out and make a profit, it really doesn't count. It's not worth anything. So the weird part was when the defendants came in and said, well, it should be $1.30. That's the value of the copper in the ground. We went through the studies of the copper in the ground that Southern Copper had and that Minera Mexico had. And if if you did use $1.30, you just couldn't use the same analysis that had already been laid out.
Right.
Because interestingly, Southern Copper had a lot more copper a little bit deeper.
Right.
That could be gotten out at $1.30. So if it was $1.30, the value of Southern Copper was tremendously higher. And they just ignored that and said, well, if we use $1.30, the Minera Mexico value goes up. And we did show, and I think this came out in the opinions, that okay, if you say the value of the copper is $1.30 per pound, then the whole analysis is completely different. The discounted valuation is through the roof for Southern Copper, and it's a little bit higher for Minera Mexico. So it was just a really bizarre situation. But trying to come in as a defense position and say we need to use a different valuation for your base metal that you're trying to extract from the ground from the one both companies have used or are using and have used for a long time is just, I don't know how a judge could possibly or jury could possibly accept that.
And it was worse than that, actually, because if you recall that, Minera Mexico had been shined up, right? Mintech had come in and done a very recent analysis on the best possible reserve report they could prepare at current copper prices. Whereas what they were looking at from Southern Peru, the most recent analysis that had been done was from 98 or 99. So again, this idea that they were trying to do things on a relative terms, they were never comparing apples to apples.
Never.
I think Mintech, even we found out in discovery, this kind of got into a more complicated issue for the chancellor to deal with on, I guess, evidence after the date of the transaction. But after the fact, Southern Copper had hired Mintech too to do a similar analysis. And at the lower copper prices that were in play, 90 cents or whatever, I think Southern Copper's reserves increased by 87% or something to that effect.
Yeah, so there were a lot of complicated sort of details in the valuation. They're all in the opinion, and it's probably not the most interesting part of the case. But yeah, it was really surprising the defense positions here. They honestly, they just struck me as silly from day one. But we did have, there was a couple interesting. I'd like to try to say some things that aren't in the opinion because everyone can read the opinion. But we were at trial, and this was a case. This was an unusual case because this is not a settlement. This case was tried, and then went on to appeal, and we won the appeal, and then we had to collect the judgment. I mean, they had posted a bond. They were threatening not to pay it. So this went all the way. I mean, this was complete litigation, litigated till the end, and a judgment was collected. But we were at trial, and it was a little weird because it was Vice Chancellor Strine when we started, and then he got promoted, and he was Chancellor Strine halfway through the trial. But Chancellor Strine called us over to the bench when, after the first early witnesses, and basically said, "You're not going to win. You're not convincing me. What is going on here?"
Not a drop of blood on the floor,
Not
as
a
I
drop
think.
of blood on the floor. There's nothing, and that caused the case to be unable to be settled. The defendants became wildly confident, and I don't know why he did that, but that is what happened. And we redoubled our efforts after that to focus on our key points.
Right.
But it was a strange thing to be called to the bench and be told you're in deep trouble.
Well, and the lead attorney on the other side, Alan Stone. I mean, you knew Alan or know Alan very well over the years.
Yes, we had both clerked for the same Supreme Court justice, and he's been a friend of mine for, or an acquaintance for a long time. And what was he supposed to do? Honestly, when he was told by the judge, basically, I think you're going to win. But we did not give up. We tried to refocus the thing. And my idea was always, let's just simplify it. Let's just keep the focus on, they're just buying a business. What's the business worth and what are they paying? And because they weren't paying cash, there was some issue. There was certainly an issue about, or the defense was trying to make an issue about what are they really paying? Like, what are they really paying and what's it worth? And ultimately, we prevailed on that because they were trying to say, well, we're giving stock, but it's not worth the market price. So that's, that ended up being their main argument.
Right.
And that's really the basic reason that we won, because the court said, no, you're issuing stock of a publicly traded New York Stock Exchange company. And no one has you haven't presented evidence that it's worth something less than the market price, or any convincing evidence that it's worth something less than the market price, which is really where they turned as their focus on this thing.
So, and this is kind of off topic a little bit, but it's always surprised me that, here's Southern Peru, where very competent and reputable members of a special committee advised by world-class advisors really were proved to have gotten it so wrong at trial. But yet, after seeing that, the chancellor went on to pen MFW, which kind of created this new doctrine in Delaware law that allowed controlling stockholders to avoid entire fairness review. Did that surprise you?
A little bit. I mean, to me, though, all these cases sort of turn on their facts, because even under a different standard, if you're able to prove that the special committee really didn't function properly based on the particular facts of your case, then I, you know, then you can win an entire fairness case.
Sure, if you get to discovery to prove your
And
facts.
it's hard to get. It is difficult. And we in a sense, we lost part of summary judgment. I think it's fair to say, right? I mean,
Sure.
he dismissed
The special committee.
the special committee. You know, most of the directors, and I personally think, you know, Chancellor Strine you'd have to talk to him. I think he regretted it in the end, because once he really sat through the trial and understood what these committee members did, I think he would, in retrospect, not have dismissed them. But as he said to us, it really doesn't matter. You're trying to recover the difference between what you paid and what you acquired, and that money's coming from the controlling stockholder. So why does it really matter if there's individual defendants? They're not going to be paying this judgment. It's coming from the controlling stockholder.
Wait, which of course is true, but do you agree with the sentiment, or do you think that independent or purportedly independent directors that are involved? Because prior to, I mean, you know, we had argued, I believe that you know, you can't make that decision, you know, at this time and stage. You need the trial to determine whether or not these directors should be held liable. Do you think that you know, directors that, you know, aren't necessarily self-interested financially in the deal, do you think that they should face the potential liability as along with the controlling stockholder, or does it not matter?
I frankly am a realist. I don't think it matters, because the money's coming from the controlling stockholder. So having the individuals in there, it might help drive a resolution, because they're afraid there'll be a judgment against them. But it really, honestly, having done this for 30 years, it doesn't really matter. When there's a large controlling stockholder that's fully liquid, I mean, they were worth $30 billion or whatever, Grupo Mexico. So there was, they can pay the judgment.
Right.
To me, it didn't work. In our case, trying too hard to keep these individuals in the individual committee members in the case just didn't strike me as something that was going to change the outcome.
No, yeah, I would agree, but it did matter. I mean, you remember Jimmy Brandt from Latham Watkins?
Yeah.
Yeah, he was, he really wanted to get that partial judgment order in place to make sure that his clients were free and clear.
He was trying to settle the case. He couldn't get the money from the controlling shareholder. He wanted to get his people out, but it all worked out great because nobody wanted to settle. And it was an easy case for us because we tried to settle the case for a number way less than the $2 billion judgment that we obtained, and they wouldn't do it. So we were lucky it worked out.
We were lucky they wouldn't
But there's
negotiate with
a
us.
couple other aspects of the case we should probably talk about. Like, I don't know what you want to do. I don't know.
Yeah, I think that, we can move on to whatever you want to talk about.
There's one really disappointing or upsetting aspect to the case to me, and the opinions mentioned that we delayed the case. We did not, absolutely positively did not delay the case. What actually happened? And so we didn't appeal those points because we were focusing on winning the case. And there was, but this suggestion that we delayed the case bothers me to this day. What actually happened was discovery was served, and the defendants just drug their feet. And so, yes, we could have filed motions to compel and been more aggressive on trying to get the discovery going, but it was literally, I was in charge. It was my assessment that this is a big case. We're going to get interest on this. You know, they're delaying it, not me. And if they want to delay it, it wasn't clear to me why I needed to hurry up. And so that is really what happened. I mean, there was never a time in the case where there wasn't something pending, where there wasn't, document requests and interrogatories and depositions that we were trying to schedule because they were international depositions, and the discovery was pretty complicated, and they were really dragging their feet, and I looked at it, and it didn't, it's a long-term money damage case, and it just wasn't clear to me that it advantaged the company, the derivative case, to try to drag them in, to put all the effort in to drag out to push the discovery so that it was quicker.
Well, even if you wanted to, I mean, we took depositions all over this country, all over. When we went down to Peru, went to Mexico a number of times. Production was not only in English but in Spanish. We had to get things translated. We needed translators present at depositions. And not to mention your earlier point, coming into this is not like any of us were experts in mining or valuing mining companies. And I guess what was there was one consultant that had been hired by the special committee, and I forget but they were located way out in Montana, where you had to take a number of flights just to get out there, and then once you got there, you had to drive 2 hours. I mean,
exactly. So, since it's not an expedited case, my approach was, why, they didn't ask for a scheduling order. They didn't argue that it should move forward faster at any point.
yeah.
And so I thought it advantaged us to take our time because of the complexities involved. And it took us a long time to find the proper expert and work with him to sort of put our side of the case together. And it's a long-term money damage case. What's the rush?
And it is a little odd to be told when you've apparently taken the time to fully understand and present a case good enough to win so decisively, for you to be then told that you took too long to put that case together.
Yeah, I wasn't involved in all of the cases, from my firm, but there were other cases: Weinberger versus UOP, Smith versus Van Gorkum. There were large, famous cases, and they took a long time. And it's sometimes, these longer term cases where you're asking for money just take a little longer to play out. And so it was a little frustrating for the defendants to sort of kind of win on the argument that, gee, you should have hurried up.
Right.
When they were the ones that slowed the case down, in my opinion. And it was all we were doing was taking advantage, of a gift they were throwing our way, to to let it play out in a slower course, and it worked. Is the thing.
Right.
I mean, taking that extra time to really let the record really develop and for on our part to really understand, because the court did find that the proxy statement was misleading, so you couldn't just read the proxy statement and get an understanding of what was going on. It had to be, it had to be developed through a bunch of discovery and documents and depositions and, like you said, translating documents and understanding their financial analysis and fighting off their experts. And
It was a long process.
the case started in 2006 and ended in 2000, approximately, I think, and ended in 2012. So it was 6 years.
Yeah. So, that's I guess one downside of or I guess hit against us. What would be another frustrating aspect of the case that at least sitting back 10 years from now, you kind of still rubs you?
You tell me. I can't. I mean, honestly, I don't. That was the thing that bugs me about it. But another comment I would have was, so, we won at trial, and there's 100+ page opinion or whatever it is, and it's, you can disagree with it, but it's well reasoned. I mean, he explained, the chancellor explained what his reasoning was for everything. Obviously, the chancellor is extremely competent and intelligent, and the opinion is just as, to me, as well reasoned as you could hope for. And then there was an appeal, and they made 5 arguments, and they made 5 arguments that they admitted were subject to the abuse of discretion standard of review.
So let me just.
And I couldn't believe when I read their brief.
Why not? Tell me from your perspective, as a yeah. I mean, you've done as many of appeals here in Delaware as any. I mean, what in your view is the problem with that?
The way you win an appeal is not to argue there's an abuse of discretion when there's a 150-page opinion that is well articulated. There's, even if you're to me, even if you're a Supreme Court justice and you don't agree, there's a gigantic reasoned opinion. So to say it's an abuse of discretion, and the arguments they made on appeal were unbelievable to me. Like saying they should have gotten another witness from Goldman Sachs. I mean, that's the best they could do. They literally argued, actually what had happened was, just one example, the main person at Goldman Sachs that was representing the special committee and doing most of the work, we deposed him. There was some doubt about whether he would be able to come to trial, so we videotaped the deposition.
Right.
And in Chancery Court, it's not uncommon to use a deposition at trial if a witness can't come. And
even when a witness can come, it's not.
Even when they can come, it's just sometimes it's easier. I believe he got nervous when he realized that this is a big mess, and he refused to come to trial. And they initially said, "Well, we're not going to have a Goldman Sachs witness at the trial."
Right.
And then, literally, like a week or 2 before trial, they came in and said, "Well, we want to bring this guy from Goldman Sachs who had nothing to do with the transaction, and really didn't know anything about it. We need him to come and testify. And by the way, he can't actually come to trial. We want him to come 2 weeks after trial, or some period of time after the trial is over, and testify. And you can depose him some other time. I mean, and the court, I think, properly said, that's pretty silly. He doesn't have anything relevant to say, first of all. And we're not going to have you, the defense, sort of have a trial and then have a guy you can bring in afterwards to try to fix up whatever, once you know what the record is, try to fix up any mistakes that you made, which is essentially what their plan was. And so the chancellor properly, I think, said, no, we've got a videotaped deposition of the lead banker at Goldman Sachs. Everyone had a chance to examine and cross-examine him, and it's not even a paper record; it's videotape. I'll look at that, and that's, I'm not excluding. Sure. If you want to bring someone, fine, but we're not going to have you bring a witness 2 weeks after the trial. But that was their lead argument on appeal.
Which, if you recall, post-trial,
it's a ludicrous argument. The counsel here, the defense counsel, I think law students should read this opinion, because this is an example of how not to do it. This is an example of how to lose a case on the defense side, if you ask me. If you look at the 5 arguments they made on appeal, right. If you want to win on appeal, you don't just make abuse of discretion arguments in the face of an opinion that's 105 pages long or 100 plus pages long, because abuse of discretion means the judge didn't consider it or something. Like, he considered everything and gave an explanation of why he rejected it. And so to me, that's the definition of not abuse of discretion.
It was surprising. This is, again, they had Milbank defending the case at trial, and then on appeal they had engaged Simpson Thatcher.
Yeah. So what happened was, I talked to Alan Stone about this. So they lost big at trial, so they fired their trial counsel and hired new counsel for an appeal. And that was another weird, just a weird situation, because it's just hard to get familiar, no matter how good a lawyer you are, to be brought in after the fact and try to go through 6 years of discovery and briefing and the opinion and figure out what to argue. Right. And so they brought them in, and at one point it was clear they were trying to position the thing to have a federal question to get a cert appeal.
And that was after firing Simpson Thatcher and bringing in Munger Tolles.
Yes. And so it was just really, I'm not criticizing, I don't mean to criticize anyone, but it was just, it struck me as just not the way to handle the defense of a case at that point. And it was weird, because another thing that happened was there was a big issue in the case about the attorney's fee. Sure. Since it was a $2 billion judgment, we were awarded 15%, and we worked very hard on the case. We had invested, $1 million of actual cash from our firm, and the other firms that were working with us. And we don't have a very big firm. I mean, $1 million is hundreds of thousands of dollars of partners' money,
Right.
that they could use to pay their kids' tuition or, pay their bills. And so it's real money at risk. It was real money at risk for us. Not to mention the 6 years of work and all the hours and everything. So we, go all out when we get a case, and we did here. And we were awarded, a very, very large attorney's fee. It was 15% of the judgment, but it was $300-ish million. That was a lot of money. And it did seem like on appeal, they were more concerned with getting that than even the judgment. Trying to get that stricken down.
But did they even try to settle that aspect with us ever?
No, there was never any. At one point, Alan, I don't know. Maybe I'm disclosing what I'm not supposed to disclose. But at one point, there was an offer of pennies to settle the case. I will say, in effect, pennies. But it was a strange case because there was never any effort to settle any aspect of the case.
Right.
Which is not how I don't think that's the way to do things. When you're, in an entire fairness case, we try to settle them if we're working on the other side. Those are risky cases. Better to settle it. Just get a resolution you can live with and move on, because they could have settled this case for way less than $2 billion, right? I mean, I think we would have taken something.
Well, I mean, at some point, you have to, right? I mean, at the time, the largest settlement, in Court of Chancery was less than $100 million.
That's right, and in fact, it was a weird circumstance, and I don't want to get anyone into trouble either on this, but one of our senior partners came into my office and said, because when he saw what we were doing, he said, you cannot go in and ask for $2 billion, or it was $1 billion or whatever it was. You need to figure out a way to make what you're asking for $100 million, because the court is never going to award $2 billion. And I just said, you know what? This is what the facts of this case are, and this is what we're going to argue. Maybe we'll lose, but this is what we're going to ask for, because it's the core of it, even though there's complexity in the valuation and some other stuff, but the core is simple. They're buying something. We know what they're paying. And they weren't even arguing that what they were buying was worth something different from what we said it was. That was another strange aspect of this case. There really never was much of a dispute about the value of Minera Mexico, the Mexican mining operations that were being delivered to Southern Copper. A little bit, but that was never the issue. It was all about whether you devalue the stock. That's what the case turned into. And that's why it struck me as an unbelievably strong case, in my eyes. But it seemed like the defense and the defendants were just consumed with this idea of relative valuation, which it never made any sense to me.
Well, and we kind of started with this, I guess, but as I understood it, they were basically comparing this to a merger of equals, and coming about it when they were unable to value Monero Mexico at anything close to three. I mean, really, that's the fact pattern that killed them. Is they originally tried to value Monero Mexico at $3 billion and just couldn't do it, no matter what assumptions they made, no matter how aggressive those assumptions were. They just couldn't do it. You know, they came at it as if this was a merger of equals without really testing whether or not they were valuing each entity in similar ways. But I guess this discussion about the delay and everything, one of the things that did happen during that delay was the case was originally assigned to Lamb. We ended up in trial before at the time Chancellor Strine. You think it would have come out differently if Lamb had
Yes.
decided the trial?
Yes.
And why is that?
He told us it would have. I mean, that was another issue. We certainly weren't judge shopping, but I mean, maybe a tiny bit of our willingness to not try to rush the case along, since the defendants were trying to slow it down, we knew Vice Chancellor Lamb was near the end of his career, and he had, in a number of conferences, expressed some, I don't know how to say it, unoptimistic views about our case, a little bit.
But so did Strine.
And so did Strine. So, but I just thought, Chancellor Strine is bold. Right. And he would not be afraid, in the right case with the right facts, to grant a $2 billion judgment. I think, Vice Chancellor Lamb may well have been willing to do it too under the right facts, but I just thought it was, we didn't know which judge the case would be reassigned to either.
Right.
But, the fact was that Vice Chancellor Lamb was, nearing what everyone expected to be his retirement and moving back into private practice. And so, yeah, there was just a tiny bit of consideration of that. But, I would hope that it would have been the same outcome. It should have been the same outcome, but it probably helped. Actually, and I do believe he even mentioned to me way after the fact that he would never have awarded a fee of 15% he would never award a $300 million fee.
Right. He says he may not have come to the same conclusion on the judgment, but you've had other cases in front of Lamb that were very successful on damages. Is it fair to say that he ended up where the facts led him?
Yes, and I think we've learned that he was never afraid to, or reluctant to give whatever judgment seemed appropriate under the facts at all. But
on the fee, I could see he would probably.
I don't know. It was a large fee, obviously. I don't know if there's been a bigger fee, but he was. It's. Who knows what other judges would have been willing to, award a fee like that? I don't know.
So thinking about the fee and really the Sugarland factors in that you were in play, I mean, you think it's right that Delaware focuses on the benefit achieved rather than like Lodestar in federal jurisdictions?
Absolutely, because my opinion is the Lodestar thing is um, really misplaced, because all that does is incentivize you to churn hours, to build up hours, to try to justify a fee. And that's not the right incentive. I mean, the proper approach is the Delaware approach, which is you get paid based on what you produce. And if you can produce something um, in a more efficient way with less hours, you don't get punished for that. It's a factor, um, but sort of having a lodestar approach where you just where the goal is just have everyone work hours that are pointless on the case, or that's the incentive.
Right.
Maybe people don't do it, but that's the point of the lodestar, that just stack up hours. I just think that's the wrong approach. It's, you should be paid like everyone else in the world is paid, based on your results, not, if you can get a fabulous result in less time and with less waste, isn't that what we should be encouraging?
You would think.
Versus saying you're paid based on the hours that you put in. Again, it's complicated because it's a consideration in each approach, the amount of hours you put in. But I think, the opinion in this case explaining that Delaware doesn't prefer the lodestar approach. We prefer to focus on the performance, is clearly, to me, the better approach.
Right. No, I would agree 100%. Looking back, and I didn't realize 10 years away from this, but, it was a big case, right? I mean, looking back, was there like a moment in trial where, notwithstanding Chancellor Strine's no blood on the floor comment after the first day of trial, was there a moment in trial where you felt differently?
Yes, absolutely, and I'm sure you remember it too. I would consider their lead witness or main witness to be Mr. Handelsman, who was the chairman of the special committee, or the lead person, or one of the lead people in the special committee. He was asked, the 67 million shares that are being issued to the controlling stockholder to buy these Mexican mining operations, are they worth the market price? I mean, because if it were us, I think we would have said, there's no way we could sell that large block of stock for the market price. He said, but his answer was absolutely, they're worth the market price. And we all, honestly, we all fell out of our chairs, because that was that was the key.
That was the $2 billion question.
That was the $2 billion question. It was like, it solved all of our litigation problems, because then, based on that testimony, and I think it comes through it was a focus of the opinions, in connection with these valuation issues, that what was they always talked about the give and the get.
Right.
And that nailed down what the give was worth. There was no more issue about what the give, what the 67 million shares were worth. So
And they knew it
that
was
was
our
a
position.
gigantic surprise.
Right.
It was really surprising to get that testimony. And that's why when you go to trial in a case, you just have to keep your eyes open and keep your ears open, because you kind of never know what someone's going to say, even if they're, everyone's coached.
Right.
And some witnesses are better than others, but sometimes they throw it at, they just hand it to you. And for us, that point was dramatic. That was just a dramatic issue in thing that we really we certainly weren't counting on it. And, I would say I wasn't expecting it. We were kind of expecting, as we were preparing for this, even though, they had the defense positions were fluctuating around. We were prepared for them to say, and we had responses to say that this block of 67 million shares that's being issued to you can't possibly be sold, for the market price. It's essentially its actual market value is well below, because if we tried to sell it, there would be all kinds of expenses, and it would have to be broken up, and we wouldn't be able to. And Goldman would take a lot of the money, and or a lot of the proceeds to try to move a block that big, and that given that this was a controlled company,
Right.
I think it would have been a minority position, but that a minority position would not be worth. But he said in no uncertain terms, of course it's worth the market price.
And they never did anything to try to rehabilitate that or put another witness on to say differently.
Yeah, that was to me, that was the biggest surprise in the case, because I think if we were doing it on their side, the focus would have been the 67. Instead of doing a discounted cash flow valuation and saying it's worth less than that, you could just say, you have an expert come in and say, if you tried to sell 67 million shares, you would not get $3 billion or whatever, or it ended up being $3.7 billion.
Right.
You would be getting $2 billion. To me, that would have been a better argument. But, it's all hindsight. Their lawyers looked at it and did the best they could. And, you can say we should have done it differently. But, these were their arguments. And
These were some of the best paid lawyers in the world. That's so best respected. It's hard to get into their heads,
right? We're not criticizing
right?
them at all. It's
right.
easy after the fact to say, gee, when it's all done and said 10 years later, you should have done something different.
Sure.
And I'm sure they can pick through what we did and say, here's the things you should have done differently, because you could have gotten more money, or you could have got a bigger recovery. But, you're in the heat of the moment. You do what you think is best.
And Alan Stone had just come off of a case, entire fairness trial, where he was victorious for his client. So, very good attorneys on the other side. It's just that,
it worked. Just this is how this one played out.
Right.
But we did try to keep it simple.
Right.
Like our focus was, or our decision was, let's just try to sort of ignore the relative valuation argument, or try to get it disregarded and say, no, the way to look at this transaction is you're buying these assets and you're paying something.
Right.
And we know what you're paying. And as we discussed, there wasn't a huge argument about, or there wasn't a big difference in the argument about what the assets were that were being bought by the controlling shareholder, or sold by the controlling shareholder to its controlled entity. Um, so
The rest is history.
it's over. It's been 10 years, so it's history. And it really was, to me, I mean, there's some aspects of this Supreme Court opinion that set some rules about, or that tried to set some rules at the time about the burden of proof in an entire fairness case. But for the most part, this was a factual case. This was an agreed entire fairness case. And it had a lot to do with valuation, or it was, to me, mostly about valuation, and the special committee process it was driven by the particular facts of the case.
Right. It's not a case where new law came out of it, really, except for this burden shift issue. But it's interesting though, because how important in your view is this burden shift issue?
I've said this before. I think it's irrelevant. I mean, we've talked about this, the burden shift, and as it says in the opinions here, who has the burden in an entire fairness case only makes a difference if the evidence is, as they say in here, in equipoise. Like if the evidence is 50% that it's fair and 50% that it's unfair, the burden, you lose.
Right.
Whoever has the burden then loses. But I just can't, it's just hard to imagine. I mean, we would never go into a case hoping to be 50-50. I mean, we're trying to get 51,
Right.
49, or better. And so it seems pretty relatively insignificant to me. So that's why the whole thing strikes me as sort of a distraction. But I mean, maybe it'll matter somewhere along the line.
Right. But I don't think, if it does matter, that anybody's gonna get a $2 billion judgment.
I mean, I think if you're going to win big,
Right.
or if you're going to get, you have to. Our approach from the plaintiff side is we have to prove this is unfair, and we're doing everything we can to prove that that a transaction has happened that is wildly unfair. And we were lucky enough to do that here. It was an unusual case where it in fact was pretty wildly unfair. And again, there's so many weird facts, but the idea that in the end, they paid the opening offer was pay us $3.1 billion. And it ended up they paid them $3.7 billion. So, that's always what seemed crazy to me.
Right.
They paid more than the they could have just accepted the first offer and been done
Yeah.
and paid a lot less.
So with
And there was another issue too.
Okay.
I don't want to
Yeah,
drag
it's-
this on, but they could have put a collar
Right.
on this. They were issuing shares, and so
And they proposed. I mean, this we didn't really get into the back and forth,
Yeah.
but the special committee had proposed the collar, which was rejected. But I mean, in your view, why was that so important?
no, I thought I thought they didn't propose a collar because I thought Handelsman's testimony at trial was we wanted to lock in the number of shares. We didn't want to take a chance that we would have to issue more shares.
So, and they did propose a fixed ratio, right? That was, but in connection with that,
they wanted a fixed number of shares,
right?
which made no sense because, and it's again, you got to read the opinion. It's in there. Their argument was, this company's valuable. Its price is going to, it's going up.
Right.
It's going up and up and up. So why would you not collar this number of shares so that you don't have to issue more and shares with more and more and more value?
Right.
It was strange to not ask for a collar. I think to me a collar is pretty standard so that you're issuing a certain amount of money. Like if you decide Monero Mexico is worth X dollars, to have a fixed number of shares means that what you're paying is fluctuating. Lock in the value of what you're paying. It was another thing that the chancellor mentioned and the Supreme Court focused on a little bit too.
Right.
That it was just the special committee did a number of things that just struck an independent judge, I think, as odd and unfair. And it wasn't, it's like I said, we were never able to prove exactly why they were doing this or why they in effect bungled these negotiations in the court's view. But those were the facts.
Right. So I guess with 10 years worth of hindsight, is there anything that you would have done differently in litigating this case, besides having better help here at the firm?
No, we had obviously we had great people working with us. No, like I said, I think I would do it the same. But because of the criticism that we went too slow, I guess I would have tried to move it along a little quicker. But in the end, it worked out for us, I think, to not push it because we were not delaying the case. We were not delaying the case. It was just a situation where the defendants weren't pressing to move forward. They were delaying discovery. And our conclusion, I mean, we talked about it here, was let's just let them do it their way. Let's let it go slowly. Because it didn't seem like we would be advantaged by hurrying up.
Yeah. It's one of, I'll say, from being a young attorney coming up through this, one of the things that comparing expedited litigation to working on this case, I mean, one of the big differences for me was getting into a case that you had time to actually understand all of the facts.
I think, and that's what I've learned. It takes a lot of these cases take time. The more time you have to sort of stew over it and go back over it, have more detailed meetings with your experts, and not have to rush on it. I think you can do a better job because the most important thing in trying these cases is preparation. you got to know if you know everything, and you sort of know every line of every deposition, and that takes time. So that when you're cross-examining a witness at trial, and he says something, and okay, I know what he said at his deposition, and you can just pull it out and say, but didn't you say the opposite thing at your deposition? It's that type of preparation is what really helps to win cases, and time helps get that preparation done, because we all aren't just working on one case. We have a lot of cases to do. So, I mean, I understand the point that maybe it would be better to move it quicker, but not in a case like this that was complicated, that involved documents in another language and all these different depositions and experts, and a proxy statement that was found to be misleading, so we couldn't really tell what was going on clearly from the proxy statement. But anyway.
Well, I think that it's always nice to come back and revisit and discuss your victories. We'll save some of the losses for another day. But yeah, I appreciate you coming in.
It was nice to be here. Thank you so much.